The union government has announced that the Waqf Amendment Bill will be presented in the winter session of Parliament. That is what the Union Home Ministry has announced today.
वक्फ बोर्ड का जो कानून है, ये वक्फ बोर्ड के कानून से बहुत परेशानी है ना। एक कानून को एक शीत सत्र में हम सुधार कर सीधा करने का काम कर देंगे।
Now, the fact of the matter is there are two primary objections that have been raised against the proposed amendments to the Waqf Board bill, and these objections have been raised by AIMIM chief Asaduddin Owaisi. His first objection is that when you quote a figure like 940,000 acres of land under Waqf Board, which the government feels is a very large amount of property that is under Waqf control, and this has happened because the Waqf board actually came into existence even before the documentation process started. So a lot of it, according to the view from the government side, is that is government land which has inadvertently come under the control of the Waqf board, because this has been on since 1950s, and prior to that, even before the documentation process began. So the government now wants to regulate that how much of it is actually government land which has come under Waqf control. Because of this figure that is now doing the rounds, it has been reported that this is as much land as the army or the railways have under their control. So 940,000 acres of land under Waqf control is something that the government wants to look into and see whether there are anomalies here. To this, Asaduddin Owaisi's argument is it's a false propaganda, because if you look at the amount of land that is under temple endowments, for example, his analysis or his assessment is if you put together 3 or 4 states and look at the land under the control of temple endowments, it will come to that much or even more. So Owaisi's argument is that this bit of statistics that is being presented to support regulating Waqf board is fallacious, is a flawed argument. His second objection to this is that the Waqf Board Amendment Bill proposes to make the district collector the ultimate arbiter in case of a disputed property. Now, the argument from Owaisi's side is that if you make the district collector the ultimate arbiter, that is against the principles of natural justice, because after all, the district collector is a representative of the executive. He's not part of the judiciary. So this would amount to stepping into the territory of judiciary, which he feels is against principles of natural justice and which should not be allowed to happen. The district collector cannot become the ultimate arbiter, because by doing so, the government ultimately wants to have the final say, since the collector is after all a representative and authority under the union government, under the home ministry.
वक्फ प्रॉपर्टी जो है वो एक प्राइवेट प्रॉपर्टी है। बीजेपी इसको ऐसा बता रही है कि ये गवर्नमेंट प्रॉपर्टी है, तो ये एक प्राइवेट प्रॉपर्टी है, नंबर 1। दूसरा, एक झूठा प्रोपेगेंडा बीजेपी, आरएसएस और उनके अलाइज की तरफ से किया जा रहा है कि वक्फ बोर्ड के पास देश में 9,40,000 एकड़ जमीन है। ये एक अफवाह फैलाई जा रही है। 9,40,000 है कितने? 32 स्टेट वक्फ बोर्ड में। अगर आप तमिलनाडु, आंध्रा, तेलंगाना और ओडिशा के 13 हिंदू एंडोमेंट बोर्ड की प्रॉपर्टीज को ले लिए तो यहीं पर 10 लाख एकड़ जमीन हो जाती है। 5 साल प्रैक्टिसिंग मुस्लिम है ना, ये देख लो आप। अच्छा, कोई ऐसा लॉ हिंदू धर्म में नहीं है, कोई भी कभी भी दान दे सकता है। आप ये क्यों लेकर आए बताओ? आप कौन होते? मैं प्रैक्टिसिंग हूं नहीं हूं, मैं मुसलमान हूं। मेरे घर में झांक के देखेंगे नरेंद्र मोदी, या फिर 5 साल के बाद मोदी बोलेंगे आओ बेटा तुम मुसलमान सर्टिफिकेट लेकर जाओ।
So that is his primary objection, that here the government is trying to take control over the Waqf board, which is against Article 26, which he quotes, saying this is against practice of religious freedom as well. The argument from the government side has also been the fact that here is a case of a community that itself has on number of occasions raised the issue of properties being declared waqf, disputed properties being declared waqf properties. So the government's argument is that the demand has come from within to regulate the Waqf board and to regulate its powers. So let's then go into a little bit into what exactly is this Waqf board bill. What does it propose to do? So amendments come in the wake of disputes, like I said, across the country, where Waqf boards have claimed several properties as Waqf. The union government's proposed amendment to the Waqf Boards Act has sparked a political slugfest. The opposition parties allege that the proposals aim to deprive the Muslim community of their land, assets and freedom to manage religious affairs guaranteed under Article 26 of the Indian Constitution. Remember, what Owaisi also argues is that this is property that is donated by individuals, by private entities, and therefore the government has no business to take control of this part or the powers of the Waqf board that controls this property, which is actually donation from the community or from members of the community. The ruling NDA has in turn argued that a demand to regulate Waqf boards, like I mentioned earlier, comes from the community itself. So let's take the instance of Sayyid Nasiruddin Chishti, who happens to be the chairman of the All India Sufi Sajjad Anshin Council. He's also the spiritual head of Ajmer Dargah. He has also made this argument that this would be trampling into the freedom to manage religious affairs guaranteed under Article 26. So it's not just Owaisi or the AIMIM, there are other entities also coming out to object to the amendments. So let's then tell you what is actually a Waqf property. A Waqf property refers to a movable or immovable property dedicated in the name of God for charitable purpose by a deed or an instrument. The practice has been in existence, like I said, even before the practice of documentation began. Hence, the properties which have been in use for a long time can also be considered as Waqf properties. So by virtue of use, some properties have been declared as Waqf properties. This again the government wants to regulate. A Waqf property can either be for public charitable purposes or held private to benefit any individual's descendants. So once the Waqf has a control over a property which has been given to it, then it is up to the discretion of the Waqf board how the proceeds of that property will be used. Sometimes it can benefit the descendants of the individual to which the property originally belonged to. A Waqf property is non-transferable and it is held perpetually in the name of God. Like I said, the proceeds from a Waqf typically fund educational institutions, graveyards, mosques, but they can be also used to benefit the descendants of the original owner. What is the Waqf board? It is a legal entity with nominated members to manage the Waqf properties. The government also, in fact, in the amendments wants to bring in a provision that says it has to have a practicing Muslim as its members. So to that also, in fact, Owaisi objects and says, how will you decide? I mean, if a person is not performing namaz 5 times, would you disqualify him as a non-practicing Muslim? So there again, there's a bit of a difference of opinion around who should be the nominated members. The board typically appoints a custodian to each property to ensure its proceeds are used for intended purposes. So also let's remember that there is something called the Central Waqf Council, or the CWC, which was established in 1964. And it oversees and advises the state level Waqf boards across India. According to the Ministry of Minority Affairs, it also advises the central government, the state government and the Waqf boards on the management of their property. So this is the existing system that we know of. It can also direct them to furnish, say, information to the council on the performance of the board, particularly on their financial performance, etc. So all of this has been in place. A new act was passed in 1995, which was amended in 2013. So this is not the first time that you have a amendment to the Waqf Board Bill. In 2013, it was amended to give far-reaching powers to the Waqf Board to designate a property as Waqf property. So contrary to what we see now, the 2013 amendment actually empowered the Waqf board even more. So in case of a dispute whether a property can be considered Waqf, Section 6 of the 1995 Act reads, the decision of the tribunal in respect of such matters shall be final. So now that changes, and now if this bill sees the light of the day and it's passed in Parliament, the collector, the district collector, will become the ultimate arbiter, and the property will have to be registered with the office of the district collector. So the proposed amendments to the Waqf Amendment Bill 2024 entails a few important things. Let's just go through them. In short, the bill aims to restrict the power of the Waqf boards, like I said, to manage its properties, and provides for more government regulation. The bill proposes to make registration with the district collector's office mandatory for any Waqf property, so that the property can be evaluated. It also states that any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be Waqf property. So this is a critical part of the amendment. The district collector will be the arbiter to decide whether a property is Waqf or government land, and the decision shall be final. And like I mentioned earlier, this part of these provisions, this particular provision, is being objected to strongly and vociferously by the AIMIM in particular, saying that you cannot have the district collector as the arbiter. That is against the principles of executive and the separation of powers of executive and judiciary. So once the collector decides, the collector can make necessary changes to the revenue record and submit a report to the state government. This is what the bill states. And the bill also states that such property shall not be treated as Waqf property till the collector submits his report to the state government. So while that is pending, the tag of Waqf property will be lifted. In case of dispute with the decision of the Waqf board, appeals can now also be made in respective high courts. So currently the system in place is that a property can be recognized as Waqf even if its original declaration is suspect or disputed, because remember, the Waqf Council has the ultimate power. The provision was provided as under Islamic law. The dedication of a property as Waqf was largely oral, of course, like I said, until the documentation came into place. So the bill now seeks to omit such provisions. Thus, a Waqf property can be considered suspect or disputed in the absence of a valid Waqfnama. So that will bring a large amount of property under the purview, because those property that became Waqf property before the documentation began will then come under the scanner. So now the amendments say that the property can no longer be used till the final decision is made by the district collector. Amendments also give the central government the power to direct the audit of any Waqf at any time by an auditor appointed by the Controller and Auditor General of India, that is the CAG, or in fact by any officer designated by the central government for that purpose. In fact, the amendments also provide for ensuring women's representation on the Central Waqf Council and the state boards, with the argument that there is abysmally poor representation, sometimes zero representation of women in these boards.